Okay, I know I mentioned this before in some of my other videos, but I never got on the specifics of it that I can remember. Okay, like I told you, on all my videos, those are a bunch of laws that nobody's doing, and I'm giving you the penalties for breaking those laws, and nobody's facing those penalties, accountability. Uh, but either way, let's get into this. The legal obligations to treat innocent until proven guilty. The legal obligation to treat someone as innocent until proven guilty, presumption of innocence, means the prosecution or government bears the entire burden of proving guilt beyond a reasonable doubt, requiring evidence for every element of the crime. And the accused doesn't have to prove their innocence. That's a fundamental right, rooted in due process, requires law enforcement, courts, and society to treat the accused individuals as non-guilty, preventing pretrial punishment and ensuring fair treatment throughout the legal process, even though practical challenges like pretrial detention can make this difficult. Okay, so I've been telling people for years, you're presumed guilty from the point of arrest. If not arrest, but from the point of whatever's happening to you. And you have to prove your innocence. And you know that's true, so I'm just trying to get you to understand the legal obligations behind the obligation to treat everyone innocent until proven guilty in a court of law, but they don't do that. A lot of people are complaining about these bails, and well, that's why there's bails. A lot of times people call, I guess, liberal judges. I mean, they're from what I've seen, they're going by the law. They're playing by the law. Doing outside of what the law regulates is usurping the law. Okay, core obligations, burden of proof. The government must prove guilt. The defendant doesn't need to prove innocence. Okay, standard of proof. Guilt must be established beyond a reasonable doubt. The higher standard in law, ensuring the certainty before liberty is taken. Okay, no pretrial punishment. Accused individuals should not be treated as guilty before conviction, meaning no undue restrictions or harsher treatment. Fair process. All legal actors must adhere to strict procedures to protect the accused's rights. Okay. All legal actors, all lawyers and judges must adhere to strict procedures, the rules of professional conduct, and a code of judicial conduct to protect the accused's rights to effective assistance counsel, a fair trial, and due process, as well as a quick and speedy trial. None of that, if you see my videos, I've proven to you time and time again that doesn't happen. Why it matters: protects against wrongful convictions, and this is not just in criminal court. This is in family court. This is in probate court. This is in guardianship. No matter what court you go in, there's always a deprivation of rights because nobody's abiding by the rules or the codes. Why it matters: protect against wrongful convictions. It's a safeguard against factual errors and state overreach, reflecting the idea that it's better to let a guilty person go free than a convicted innocent one. And that's a standard I live by. And I'm not even a public servant. I'm just average Joe, John Q. Public. An American citizen speaking on his birthrights. Maintains system integrity. It upholds fairness, justice, and due process, fundamental to a legitimate legal system. Legal basis, U.S. context. While not explicitly in the Constitution, it's the fundamental requirement for a fair trial, supported by the Due Process Clause, 5th and 14th Amendment, and court decisions. I went over those with you in other videos. real world challenges. Despite the principal pretrial detention, reputational damage, and the emotional fitness toll can take accused individuals treated as guilty even if legally innocent. And you're always legally innocent until proven guilty. Now, this is for the goddess out there. She wants to ask me questions. Well, this is one of the questions that needs to be answered. They took her child. And they're dragging her through court, and she's got exonerating evidence, exculpatory evidence that could exonerate her, but they don't want to deal with that. They don't want to deal with the truth. They don't want to deal with their evidence, because then that'll prove anything and everything they did to her was unjust, beyond the law, abuse of power, violating the rules, the codes. I mean, if she was arrested, the police are legally obligated to investigate to see if it was factual or not. It could lead to a false arrest, you know. And most of the time it's from a caring call. Anybody can make a phone call, point at you, and you get arrested, and then you got to fight your way out of it. I've been there many a times, and I've used the law repeatedly to get but I knew a lot of this stuff. So even though I got arrested once I got to court, I was released when I went to court. Okay. So, first of all, the legal obligation to treat innocent until proven guilty. Okay. Wait. That's the legal obligation. Penalties for violating the innocent until proven guilty. Violating the innocent until proven guilty principle isn't a crime with specific penalties for individuals, but rather a breach of due process rights, leading to remedies like dismissed charges, suppressed evidence, successful appeals, or even lawsuits against the government. It undermines the fairness. Violation often manifests an unfair pretrial detention, public shaming, prep walks, the walk of shame, biased public statements by officials, or placing undue burden on the accused before trial. How violations occur and what happens. Pretrial detention, excessive bail. I've been there. Being held in jail because you can't afford bail despite being presumed innocent can be a violation, and that often happens when they violate your right to a quick and speedy trial. They don't even tell you limitations and exceed that, and you can get out on that. You can be in prison on, doing 20 years. If you didn't get a quick and speedy trial, you can file a motion to quash based on you not getting or not giving informed consent because they didn't give you reasonable information to give informed consent. In order to give informed consent, you need reasonable information to make an informed decision to give an informed consent. And did anybody tell you, hey, it's been 2 years, we were supposed to give you a speedy trial within 120 days. That didn't happen. So we could have thrown it out on that, but, since we didn't, if I tell you, you could sue me, the opposing party, the judge, everybody involved. So they're not going to tell you that, I'm telling you. Burden on a defendant, forcing the accused to prove their innocence or provide evidence beyond what's required by law. Biased investigations, police or prosecutors treating someone as guilty, leading to unfair evidence collection. These are how violations occur, and this is what happens. Legal resources for defendants, motion to suppress evidence if evidence was obtained unfairly due to a coerced confession, it can be excluded. Dismissal of charges if a prosecution conduct is egregious and must be dropped. Remember, a lot of times when you get arrested and you're sitting there in the bullpen, a lawyer comes and talks to you. It's usually the state's attorney offering you a cop-out. Just sign this and you can go. But the public defender will do that to you too, which is egregious conduct. That's violating your Sixth Amendment. Effective assistance counsel, fifth, fair trial, due process, So if the prosecution conduct is egregious, charges must be dropped. Even if they don't report the public defender for doing that, your public defender say, hey, just sign this and you can go, it's just a felony. They won't tell you it's a felony. Just sign this and you can go, and it's the end of it, So the state's attorney's job is supposed to say, ineffective assistance counsel, Your Honor, he's not doing his job. He violated the rule of professional conduct in its entirety. He just told him, sign this and you can go. And this kid's going to leave with a felony. He's already got two. The moment he walks out the door, they're going to put a warrant for his arrest, and they're going to catch up to him later, and he's going to be arrested as a 3-time loser. Because this happened to him 3 times. He don't know what the hell's going on. So, they don't care about you. It's all about statistics. You're a matter of statistics. What makes them look good and what makes them look bad. And it's easy to make them look bad because they're not doing this. A new trial. A conviction based on unfair procedure could lead to an appeal and a new trial. But see, you prove ineffective assistance to counsel. That's easy to prove the ineffectiveness of the court. So, violating your rights to due process, a fair trial, effective assistance to counsel, quick and speedy trial shows that, your birthright is denied in their entirety. So, new trial would literally be violating the double jeopardy clause. Civil lawsuits. Defendant may sue the government, police officials for violating their constitutional rights. Why it's a constitutional issue? The presumption of innocence is the bedrock of due process, rooted in the 5th and 14th Amendment. It requires state prosecution to prove guilt beyond a reasonable doubt, not the defendant to prove innocence, ensuring the treatment and preventing wrongful convictions. Okay, so that's not just in criminal court, that's in every court, okay? Nobody plays by the rules, nobody plays by the codes, you're not getting effective assistance of counsel. If you're not getting effective assistance of counsel, you're not getting a fair trial. A lot of courts, a lot of judges and lawyers will tell you, well, this isn't criminal court. Yeah, I know, but you're depriving me of life, liberty, and pursuit of happiness. So yes, I am on trial. If I wasn't on trial, I wouldn't need a lawyer and I wouldn't be in court. And since I do need a lawyer, you need to abide by the rules of professional conduct. All of you. You need to abide by the code of judicial conduct and enforce it. All of you. There's a lot that's got to be said. Okay. There's a lot that got to be said. Presumption of innocence. And that ain't happening. That ain't happening. You just don't know the law behind it, okay? So, Goddess, this is one of the many things that you're going to have to understand. This isn't happening. And this isn't child custody court. And the way it works, and I read it to you that, no, they're not supposed to do that. They're not supposed to make you go broke. They're not supposed to, assume you're guilty and make you prove you're innocent. But they're doing that. This woman has exculpatory evidence. And they're treating her like a criminal. And it doesn't matter if it's a woman or a man. It's what matters is the child. It's always about the children for me. It's always about the children. Children are special. They're the future. God's gift. God's gift to the world. They are the future. And I want her to have a better future. And that way, whatever I can teach her mom, hopefully her mom will teach her, and she'll teach her kids. Make this a generational thing, you know. I've always found knowing the law to be a great asset. Generational wealth, if you will. If I had children, I would pass it on to them, as you should yours. Knowledge, all it takes is opening your eyes, opening your mind. Read to succeed, my friends. Read to succeed. Nothing but peace and love to you. Long life and good health. May your Creator always be with you and rain many blessings. And with every hope that I have, may this be one of them. Have a good night.